I hope this goes well. I want to preface it by saying I'm not exactly a deep thinker on this issue, but I do have some thoughts that are based on my experiences as both the disciplinary prosecutor and the last several years as bar counsel. Some of my thoughts begin with really an unfair slide. I think that as a profession, we're guilty of talking too much too often. And I wonder, and this is completely unfair, and I know that, but I wonder if we'd have been better off today taking an hour out of our time and either going up to Chelsea or manning the phone lines and helping people. Just helping people. I think sometimes, and you'll see this in a slide later on, as a profession, we let the perfect be the enemy of the good, and right now we're looking for the perfect solution to the access to justice problem that's out there, when in fact there are lots of good things that could be done, and I'm going to go through them over the next 20 minutes or so, that we could just do. And I think that would bring more help to people who need it than more and more and more of this. And on that note, I think one of the things we need to do to help increase access to justice is we need to stop being lawyers. And by that I mean that we are great at forming committees and commissions and issuing reports and publicizing our reports and telling people how great our reports are and then basking in the glow of those reports, but then we don't really follow up on those reports. History is littered, even here in Vermont, with reports and recommendations of how to improve the system and no follow-through. We're still talking about the same things that have been talked about for years. The Vermont Bar Association has a journal. Not the magazine, the journal. It used to keep an actual book of its annual meetings where everybody who spoke was quoted, and they had their entire speeches reproduced in a sort of a journal of the meeting. I was reading one recently where they were lamenting the access to justice problem and cuts to the Legal Services Corporation's budget. Do you know what year the journal was, what year that speech was given? 1966. That's 40 years ago, and we are still talking about the exact same things. Now, I don't know if the problem is unsolvable, and certainly access to justice touches on many more areas, societal problems, than just the ethics rules, but it strikes me as strange that we're still talking about the very same. I mean, I was just in D.C. a month ago advocating for an increase to the legal services budget and Legal Services Corporation budget. So it's an issue that we seem to have failed to address. Here's the problem. In 2012, Judge Davenport, who at the time was the administrative judge, did a study that showed the stark reality of where we are today. Active parentage cases, 84% of the people don't have lawyers. In landlord-tenant cases, 90% of the tenants don't have lawyers. Only 24% of the landlords don't have lawyers. Collections defendants. I know we have some small claims experience here. In collections cases, defendants don't have a lawyer 84% of the time versus only 2% of the time for the plaintiffs. Foreclosure cases, 74% of the time, defendants don't have lawyers. Divorce cases, 54% of the parties don't get lawyers. This showed that those 5 cases where it's more often than not people don't have lawyers account for 72% of the entire civil docket. And that was in 2012. As a result of this study, in 2014, the Chief Justice, he sort of issued a call. We got to do something about this. And what he said was that the bar, the court, the legal education providers, the business community even, we need to come together to study the question of how to ensure that Vermonters can obtain quality, affordable legal representation. And he said that we have to do so even in the face of the stark financial realities that we face right now. We can't use a lack of money as an excuse. And I'm going to show you some things, I hope, that will show you that we don't need money to use the ethics rules to help solve the access to justice problem. Here's another example of lawyers being lawyers. As a result of the Chief's speech, the Bar Association formed the Vermont Joint Commission on the Future of Legal Services. Professor Cole, were you on one of the committees or not?
Not this time around.
Okay.
Yeah.
Claire, were you?
Mm-hmm.
Which committee were you on?
I think I was in the legal aid.
Okay, well, I was, so,
Yeah.
but you weren't.
All right.
So then it was one of those
Okay.
committees.
All right.
Oh,
So,
the ad hoc committee on attorney supervision.
okay.
Yeah.
So we had this commission formed that we were going to study how to solve the access to justice problem. And we had great people, really interested people, who were on this committee, and we came up with some really great ideas. Licensing paralegals, creating alternative paths to licensure to let more people get licensed without being massively in debt. Getting collections cases out of small claims court, freeing up small claims court to hear other types of cases. Creating a business court. Creating a statewide office for access to justice. A lot of different, using lawyers and law students as navigators in the court. Changing the judiciary's website. Embracing technology. These were great ideas that would help improve access to justice if we did something about them. But so far, you know what our only tangible result has been? Any guesses?
The website.
The website.
No, we haven't even done that yet. Our only tangible result so far is the report. And it's a great report, and we had copies of it that were bound and it's spiraled with nice color on it. It's awesome. But it's a report, and yet here we are. Here we are. Now, don't get me wrong. I don't want to say that we're not doing anything about the access to justice problem in this state. Here are several programs in place where people are helping. And the bulk of the work is being done by the groups on the left there. Legal Aid, Law Line, and the Defender General's Office do fantastic work helping people access the courts. There are also clinics here that do a great job. There's the Vermont Volunteer Lawyers Project. The Chittenden Small Claims Clinic does a pretty good job. I think the Chittenden Rent Escrow Clinic does a fantastic job. They're now going to try to replicate that in Rutland County to get landlords some help. It's a program where lawyers from firms go in and volunteer, and they meet with a tenant right before a rent escrow hearing and try to get the tenant some immediate short-term advice. The VBA has several programs. The Modest Means program, which captures people who don't qualify for legal aid but really can't afford a lawyer. Then there's all the county bar pro bono and low bono programs. So there is good work being done, but what am I going to say right now? Yeah, here we are. We're talking about it. We're now to the point where, can we use the ethics rules to get something done? And here's my challenge to you, because there are people out there, very smart people who have written about this, who argue that the ethics rules stand in the way of access to justice. I disagree with that. Some of them do arguably prevent people from doing more to increase access to justice, but here's why I argue against this. My challenge to you, do things. Do things to help increase access to justice, and dare people to tell you, don't do that. And dare them to answer you when you ask them why not, and then dare them to call it unethical. Now, caveat, I'm not asking you to put your license at risk, or for you law students, your admission at risk, and I'm not saying it's okay to violate the rules. It's okay to be unethical. What I'm really saying here is that we cannot possibly live in a world where we are going to interpret the rules of professional conduct as preventing lawyers from helping people who need help. Because then, if we live in that world, and if we're going to take that position that the ethics rules keep me from helping people who need help, we have decided that it's unethical to help people who need help. And that is crazy. That is absolutely crazy. So I do not want you out there saying, oh, I'd help, but I might lose my license if I do. Because I guarantee you there's nobody in my job, anywhere in this country, who's going to take away your law license for trying to help people who need help. So if there's anything I want to get across today, it's this, that helping those who need it most must be ethical. It's that simple. And it's really simple to do under the current rules. So my thoughts going forward today are based on what I've seen. And what I've seen is this. When I started as disciplinary counsel, it was in the year 2000. And since then, I've reviewed pretty much every complaint that's been filed against a lawyer in Vermont. That adds up to about 3,400 complaints over the last 16 years. And so I've got some insight, I think, on what we can do to help people with access to justice using the ethics rules. A couple things for you. These are actual quotes right from the preamble to the rules. And I think these quotes show that the rules are actually intended to help ensure that we have access, people have access to justice. A couple of the quotes. A lawyer is a public citizen having special responsibility for the quality of justice. A lawyer should seek improvement of the law, access to the legal system, access to the administration of justice, and access to quality legal services rendered by the legal profession. The preamble also says that a lawyer should further the public's understanding of and confidence in the rule of law and the justice system because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. So what that means is if people aren't feeling like they can access the courts, they're going to lose confidence in the system, and they aren't going to participate. And I think that's already happening. I think people are going to go outside the justice system to resolve their disputes, where essentially we're going to privatize dispute resolution. I think we're already seeing it, and I think if we don't start doing something immediately, it's going to happen more and more often. Finally, under the rules of professional conduct, lawyers should be mindful of the deficiencies in the administration of justice, and there are many, and of the fact that the poor, and sometimes persons who are not poor, cannot afford legal assistance. I think sometimes we lose sight of this fact. People sort of poo-poo it as, oh, this is just the poor people. Now, that's a problem in and of itself, saying that. But you know who else can't access justice? Lots of people. People who otherwise have well-paying jobs and are, working every day, raising families, having homes. They can't access justice. It's too expensive. It's too slow. It's not just a poor people problem. So don't blame it on them. So the preamble concludes with 2 slides here. All lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. And a lawyer should aid the legal profession in pursuing these objectives, and this is the key sentence, and should help the bar regulate itself in the public interest. So if that's the concluding sentence in the preamble, should help the bar regulate itself in the public interest, what do you think I'm going to tell you that means? This is a sentence in the preamble to the rules of professional conduct. What do you think I'm going to tell you that means? That means that the rules certainly are intended to encourage access to justice. Because if we're going to regulate ourselves in the public interest, we should be regulating ourselves as a profession in a way that makes sure people can access the courts and access legal services. And don't forget, we get to regulate ourselves. We get to draft the rules. We do. Not the legislature, not the executive, we do. So let's either make sure they're drafted to ensure access to justice or change them, if they need to be changed. Now, sort of a big picture thought here. What should the rules of professional conduct prohibit? That is, in designing the rules, what should we endeavor to make unethical? And my thought on that is this. We have a lot of rules that talk about a lot of different things that are supposedly grounds to lose your license. I think we should interpret the rules as prohibiting lying, cheating, and stealing. And that's pretty much it. And there's
Incompetence.
Well, right, but I think that's cheating. That's cheating your client. That's stealing money from your client. I think you can fit everything into these 3 theories. Lying, cheating, and stealing. And helping those in need is not lying, it's not cheating, and it's not stealing. So it can't possibly be unethical. So here are some things I think we can do immediately. These are quick fixes that I don't think would take a lot of time. They can be done right now to help improve access to justice. The first is I think we have to amend the rule on the unauthorized practice of law, and we have to authorize paralegals and others to provide legal services or provide services to people that right now only lawyers are authorized to provide. And when we do that, we need a little dose of humility. This is a quote from Andrew Perlman. Oh, sorry. This is a quote from the legal I should have recognized this quote because I wrote it. This is the Legal Education Committee that was on that Vermont Commission on the Future of Legal Services. Dean Mahaly was on it with me. We wrote that not all legal services require delivery by a person with a law degree. That given the staggering number of cases involving self-represented litigants, there are routine matters in which common legal services could be delivered competently with proper training. This is Andrew Perlman. He's the Dean of Suffolk Law and has written a lot on the future of the practice of law. We have to identify those services that can be performed competently with training short of a law degree and which ones don't require any specialized training at all. And the focus isn't on whether a particular service can be performed by someone who doesn't have a law license. That's what it's on, not someone who can perform the service best. Because right now, we don't even require that services must be performed by the most skilled lawyer out there. So as long as, like just said, if someone's competent, we should authorize them to provide legal services, and it should not be a violation of the rules of professional conduct for an attorney to have paralegals who are representing, for instance, tenants in rent escrow hearing. I don't think. So what I think we need to do right now, this was our recommendation, identify the areas that legal services can be provided by paralegals, not by a lawyer, design and implement educational programs that will train them to do so competently, get lawyers to work with them, and then develop a program to license them, make sure they get continuing legal education, and make sure they comply with the ethics rules. Now that last thing, does that seem like it would be hard to do to you? Figure out how to license them, make sure they get continuing legal education, and make sure they comply with the ethics rules? Some people say, well, that's a daunting task. I say, no, it's not. Because you know what? We already do it. We license lawyers, we make sure lawyers get CLE, and we discipline lawyers. We just fold paralegals into that same process, and it'd be very, very simple, I think. These are the areas that we identified that paralegals could help right now. Landlord-tenant, particularly the rent escrow hearings. Family law, just getting them through the forms. For those of you who haven't been in family court before, the forms are daunting. There are hundreds of them on the court's website. And it's kind of crazy how they set them up because they don't even name them, logically. They have these weird names. Like one form should be called first form or start here. But you can't even figure that out when you go on the website. So people actually need a lawyer just to figure out the forms they need to fill out, and that's bizarre. The most important form is the, the section 8, the Form 813, the income affidavit. Why is that called Form 813? That makes no sense. Nobody who's getting a divorce would know logically, oh yeah, probably number 813 is the one that's going to be most important to my case.
Part A and B.
Yeah, and then that.
That's a separate document.
We think that there could be room for paralegals to help in collections cases. Like I said, I think this could be done quickly. There's an educational infrastructure here in place. The VLS was on board. Champlain College was on board. We already have the admissions process. We already have a disciplinary process. I think we also have to open up the practice of law to more than just paralegals. Law students, inactive attorneys, and retired attorneys. Inactive attorneys and retired attorneys right now are not authorized to provide pro bono representation to people who need it. Because that would be the practice of law, and to practice law you need to have an active license. Many other states have created a category of licensure called emeritus or something like that, where lawyers can go inactive and save a lot of money, or they can simply retire, but they're still authorized to provide pro bono legal representation to people who need it.
What do you do about the insurance issue in those circumstances?
That's something that the lawyers are going to have to figure out with the carriers. I think we should give the lawyers the opportunity to do that.
Carriers, let me tell you. They listen to us all the time.
Well, and also, don't forget, if you do it under the auspices of the Vermont Volunteer Lawyers Project, you're covered under their policy. So, another thing I think we can do to help ensure access to justice is make sure lawyers understand Rule 1.2c of the Rules of Professional Conduct. And that rule says that a lawyer may limit the scope of the representation of the client if the limitation is reasonable and the client gives informed consent. This rule has been on the books for quite some time, and the purpose of the rule, you'll see sort of there at the end, is that this is intended to give lawyers a way to expand access to legal services by providing limited but nonetheless valuable legal services to low or moderate income persons who otherwise would be unable to obtain counsel. So really the point is, I can't afford an attorney for a full-on divorce, but maybe I can get the attorney to help me in the dispute over, who gets custody of the kids, and my spouse and I can work out everything else. I don't think it's used enough. The rule specifically says, and again, this is another thing where insurance could come into place, that not only can you limit the representation, the client can limit what the lawyer does. So for instance, the client could say, I'm willing to go to trial without you doing any depositions. I can't afford them. I can't afford your time, Adam. I can't afford the cost. I don't know that that happens in practice because I think a lot of lawyers would be nervous to do that. But the rule, which is an ethics rule, says you can do it. And I think if more lawyers knew about the limited representation rule and sort of advertised their services as I will provide limited, discrete, task-based representation, that cost X number of dollars, and you won't get in for the whole kit and caboodle. I think there are people out there who may take advantage of that. This is a rule that's on the books. We just need to make sure lawyers are aware of it, and that they make their potential clients aware of it too. Nothing we would need to change. Related to this, I think we can increase access to justice by allowing ghostwriting. I'm going to talk about that in just a second. I think we can also increase access to justice by educating lawyers on flat fees. We have a new rule on flat fees. It allows lawyers not only to charge a flat fee, but it allows a lawyer to treat the flat fee as their own upon receipt, subject, of course, to being refunded if it was later deemed to be unreasonable. We've allowed flat fees for probably 10 years now, and for many years, lawyers were reluctant to use them because the rule said you can charge a flat fee, but you can't treat it as your own until it's earned. And then it had no guidance on when was it earned. And most clients are perfectly willing to say, you can treat this as earned upon receipt, just do the work for me. So now the court agreed to change the rule to allow lawyers to treat the fees as their own on receipt. And maybe that's a way to help increase access to justice, to go with flat fees combined with limited representation. I think ghostwriting needs to be, we really need to clarify that. Does anybody know what the ethics issue with ghostwriting is? There's a couple. A lot of courts have criticized ghostwriting. First of all, let me tell you what ghostwriting is. So say I'm a non-lawyer, I have a legal case, I get a lawyer to write my pleadings for me. You know, I pay the lawyer, $500 or whatever to draft a complaint, more often to write a motion for me. But then I present it as my own to the court. That's ghostwriting. And a lot of, traditionally, states and courts have been opposed to that. That is shifting now. More and more states and courts are permitting it. But does anybody know what the ethics issue there is? Sort of. Same thing as plagiarism. It's passing off somebody else's work as your own. And go ahead.
Can you distinguish that from what lawyers do for clients all the time?
The thing there is they're actually signing their name to it. So what a lot of courts said originally when ghostwriting started happening more and more was it's unfair to the other party because if a judge thinks that somebody is pro se, they're going to give them the benefit of the doubt with the liberally construe a pleading. And a judge wouldn't do that if the judge knew that in fact a lawyer had written it. Other judges have said, well, this is flat out dishonesty by the lawyer to write it and then not alert me to the fact that he or she wrote it. The Second Circuit, fortunately, a couple of years ago, issued an opinion and said, wait a minute now, we're not gonna say it's per se bad. And they relied in that on an ABA opinion from 2007 that said lawyers can provide legal assistance before tribunals pro se and help them prepare written submissions without disclosing or ensuring the disclosure of the nature. Sorry, I bungled that quote. Basically, the ABA said lawyers can do this because doing this is exactly what a limited representation contemplates. We're going to say that it falls within that rule and you don't have to disclose the fact that you're doing it. So people say, well, that's not fair because what about the rule that pro se litigants are entitled to a liberal construction of their pleading? And what the ABA said was, well, if the undisclosed lawyer has provided effective assistance, that's going to be obvious to the judge. So therefore, the judge won't give any unfair treatment to the pro se litigant. And then they said, but if the assistant was ineffective, the person's not going to get any benefit out of it anyway. So what the ABA has said is because there's no reasonable concern that the pro se litigant will receive an unfair benefit as a result of a ghostwriter, we should allow it. Now, the Second Circuit and other states, mainly New York is the one who's addressed this most often, have put some conditions on that, saying if a litigant is asked and lies about it, that is a problem. Or if a lawyer is asked and has lied about it, that's a problem. Some courts have a rule that says, yeah, we understand ghostwriting is going on, and if so, you have to disclose that in the pleadings. So you do have to follow court rules. And then New York also said that absent an affirmative misrepresentation or a violation of the court's local rules, it's not dishonest, so we should allow it. So my thinking is this. I think ghostwriting, which I know what's going on, should be considered a limited representation under Rule 1.2C, that we don't have to require lawyers to disclose the help they're providing to clients. And this is an easy fix. We could just adopt a comment to the rule right now that said ghostwriting should not be considered a violation of the rules. Because you know what? We've done that. We just did this with Rule 1.2D and providing legal advice to related to legal marijuana to clients. Because just sort of digressing here. There's a rule that says you can't advise or assist a client to violate the law. It does not draw a distinction between state and federal law, or between federal law that is enforced and federal law that is not enforced. So in Vermont, there are many uses of marijuana that are legal. For instance, owning a dispensary. You can own a medical marijuana dispensary. Those people need legal help because that is a significant business to form and to undertake. So we want those people to be able to go to a lawyer and get legal advice to how to run the business. Lawyers would say, whoa, I don't know if I want to do that because even though it's legal in Vermont, it's illegal under federal law, so I don't want to be accused of assisting my client to violate federal law. Lawyers had the same battle in Colorado, they had the same battle in Washington, they had the same concerns here. So what the court did just recently is adopt a comment to the rule that says, if you advise your client on something that's legal under Vermont law, you shall not be prosecuted under Rule 1.2D for advising your client to do something that's illegal under federal law. That makes no sense. So I don't know why we don't do the same thing with ghostwriting. Just put a little comment in there that says ghostwriting shall not be considered unethical. I think ghostwriting is a great way to help people get access to justice. It's no different than a limited representation. And you know what? Not only that, there are lawyers right now out there who are contract attorneys who write briefs for other attorneys, and they don't disclose that fact when they turn them in. So why are we allowing that, but we won't allow it for the pro se person? I think there's another quick fix we can make, although I'm not positive it's an access to justice issue. I think it is. I think we can relax at least the ban on providing financial assistance to clients. Here's the rule. A lawyer shall not provide financial assistance to a client in connection with pending or contemplated litigation except, and this one really doesn't apply to what we're talking about today, this one does. A lawyer representing an indigent client may pay court costs and expenses of litigation on behalf of a client. Is rent a court cost when your client's facing an eviction? No, it's not. Is food? Nope. Nor is necessary medical treatment in order to get a job to earn a living to pay your rent, to avoid the eviction. The rule is intended to encourage, to not allow lawyers to subsidize a lawsuit because, God forbid we allow that, because then a plaintiff might just pursue a frivolous lawsuit because they don't have a financial stake in it. But here's real life. I just talked about it. Client's lost a job, lost benefits, and needs to feed his kids. Can you advance $500? Nope, you're not allowed to. You could lose your license for doing that. Same thing with advancing rent, which I just talked about. So essentially, we've decided that compassion is unethical. And is there really any harm in either example I just cited about advancing rent or buying groceries? Is there? Maybe there is.
It may come up only in terms of, say, a settlement is offered improper, then suddenly the attorney has an interest in the outcome.
Right. That's what people said. Yeah, the attorney may advise that you take a settlement that you otherwise wouldn't take just because the attorney wants to get his or her money back. Well, so the final thing I have there is, has anybody thought about these questions? And yes, several states have. In Alabama, you can provide emergency financial assistance to a client without losing your license, as long as you don't promise it in order to get the person to hire you. In Louisiana, you can advance minimal necessary living expenses. In Minnesota, you can guarantee a loan to withstand delay that other sides will intentionally cause in order to pressure people into settling just so they can settle and get something instead of waiting years for nothing. In Mississippi, you can advance minimal living expenses. For example, rent to avoid foreclosure, repossession, and you can also advance necessary medical treatment, money for necessary medical treatment. New Jersey has modified their rules so that it doesn't apply to nonprofits. So for instance, legal aid down there, legal aid type providers can advance rent and other costs of living. And here's what the Louisiana Supreme Court said 40 years ago. No bar or disciplinary rule can or should contemplate depriving poor people from access to court so as effectively to assert their claim. That was 40 years ago. And I just think that that's exactly what we're talking about today. That we shouldn't obsess to prohibit common sense compassion, that we should trust our disciplinary prosecutors and our disciplinary boards not to sanction lawyers who are trying to do the right thing. And if we have to, let's remember who writes the rules. We do. So we have the power to make sure that the rules are written in such a way as to ensure access to justice. Some other ideas I have that aren't necessarily quick fixes to the rules. They would require some doing. Like Professor said, competence is a big issue. And knowing that there are so many people out there in these discrete areas of law who need legal help, we should start educating law students to be able to provide legal help of that exact nature. Massachusetts has done that starting starting next month in July. The Massachusetts bar exam, is anybody here taking it? If you are in the future, it's good to know. They're going to be testing on access to legal justice issues. For instance, foreclosure cases, landlord-tenant cases. Those are the two specific ones. You're going to have to know those. It's going to be on the essay portion of the test because they want law students and new lawyers to be competent to represent these people right away, as soon as they're admitted. I think we can also relax the conflict rules, in particular for the Defender General's Office, their contractors, and the legal aid folks. Right now in Vermont, we do not recognize the wall. If anybody in the office has a conflict, it's imputed to everybody in the office. That's nuts in the Defender General system. So you have two assistant public defenders. One's got the kid in a juvenile case. Somebody else in the office has got the kid's dad in a related criminal case. They never even see each other at work, not to mention talk to each other, but they have a conflict. And I think we got to relax that to make sure that those people get representation without getting delayed until we find them conflict-free representation. Bigger picture stuff, I've written about this on my blog. I think we need to consider amending Rule 5.4. Rule 5.4 is a rule of professional conduct that prohibits lawyers from allowing non-lawyers to own their business or have any management say in their business. I think it's time to look at changing that rule that all the Commonwealth nations have. There's been no damage so far as a result of having done so. In fact, there's been help. There's been a surge of investment. Are you against that rule?
I'm restraining myself remarkably, but I get to say
Okay.
12:45 questions come.
Yep.
So.
And I think we also have to recognize that some of the so-called legal disruptors that Attorney General's office mainly have gone after for the unauthorized practice of law, they're doing good work. They're letting people get into court, whether it's LegalZoom and your $99 forming or writing your own will. We have to recognize that they're going to be part of the game going forward, and people are turning to them. And how are we going to deal with them? And I think we have to make sure that we do so in a way that doesn't lose sight of the fact that they do provide a benefit to some people. I think we should all, beyond the rules of professional conduct, we can consider giving MCLE credit for pro bono work. And so here's some other little projects I've had that, I don't know, maybe they'd help, maybe they wouldn't. I don't know why we don't have more night courts or weekend courts. A lot of people who can't afford legal services, if they do go to court, whether they have a lawyer or not, they're going to court during the day when they're missing work. And so they're losing what little money they have. And in particular, it drives me nuts when people who are behind on child support payments are summoned to court to explain why, and they're missing work to go sit there for 2 hours before they get a chance to talk for 5 minutes. And I think that's nuts. I think we should be more amenable to having court after hours, whether it's at night or on the weekend. I also think we need to get rid of block scheduling. This may only happen in Chittenden County, but here's what happens. If you have it usually happens in the criminal cases. You're charged with a crime. You show up for your calendar call. They tell 50 people to be there at 8:30, and then they get to you when they get to you. They might not get to you until noon. Now, none of you here would continue going to a dentist who said, okay, everybody here, your appointment to get your teeth cleaned is on Friday morning at 8:30, and then we'll get to you when we get to you. Why do we do the same thing as a system to the people who are coming into our system? And I think there are ways we can streamline small claims court, but that sort of gets beyond this discussion. So I guess in conclusion, let's write and interpret the rules sensibly. Let's not use them as barriers to helping others. Let's live up to the ideals we've set for ourselves. Otherwise, I think we're no different than the emperor with no clothes if we say we have this great system when in reality it's either penalizing lawyers for helping people or not helping people at all. That's the end. Now I'll take
Well, for lawyers in practice, Michael's thrown down the gauntlet in a whole bunch of areas. So I can't imagine that we can do this in 10 minutes. But think about a question or two, and let's, because we can go till 5 of 1.
Let me try this, and overlooked in all of this is what I know small town practitioners encounter on a daily basis. It's, hey, Mike, can I ask you a question?
Yep.
You get the phone call in the office, you spend 10, 15, 20 minutes on the line with the local guy who's not going to retain you, you're not going to send him a bill, but you give him the guidance or the support he needs to pursue whatever he's doing or she. And I think that's a vastly undercounted area for particularly small town sole or small firm practitioners. Yep. They do it every day. I mean, I
Just show up.
it's endless.
There's the door, you sit 'em down.
So you want to list that, or is that a question?
No, I
No, I
think
think-
it's not a question, it's more an observation.
Discussion.
No, it's an observation. I'll say this. Maybe my tone today was more challenging. I don't dispute at all that that's going on. I think Vermont lawyers are doing a fantastic job, especially that exact situation. Free legal advice to people who need it, just because you're good people.
Every day, all day.
Yeah. Yeah, I think that goes on more often than not.
It's the best form of advertising there is.
Yep.
But having said that, Amy Davenport's report, still, there's a huge problem. I don't think
Right.
anybody
People
would
aren't-
disagree, right?
yeah. And I think I didn't touch on this, but one thing we can do in the problem, it's not only on lawyers to solve the problem, we have to do a better job explaining to people the benefit of having a lawyer. And it's not just, there's a lot of people out there thinking, why would I hire a lawyer? I can do this myself. And then all of a sudden they get there and they can't even figure out the first thing that's going on. There are benefits to having a lawyer, and I think we need to do a better job of explaining those to people.
Maybe somebody will listen to you, but they're not listening to me.
Right.
I do a lot of mediation work, and what I've been finding, at least in some of the what we need is a domestic portion of the family court that will deal with unmarried people. Because I've got folks in, they've gone through PR&R, they've got their child support and all, now they're stuck with the house, what do we do with that? And the only remedy they have there is a partition. And so there are 3 separate proceedings now, and the one that usually gets the stiff end of it is the partition, because they can't afford that, and that's a nightmare. So there should be some kind of fully enveloped parentage action that they can do pro se with the necessary forms.
Yeah, that's an interesting point. I know that, and this may not directly respond, but I know that when Judge Sontag was sitting in Brattleboro, he came up with that integrated domestic violence docket to try to get it so the relief from abuse, the family law issues, and the criminal thing were all combined into one, so you didn't have 3 different appearances on 4 different days.
We have a rule, we could do it under the master's rule.
Okay.
Or you could set it up through there where the special assignment comes to presiding judge in these kinds of cases. You could do it court by court throughout the state, and I think that would take a lot of the burden off. The case that we're seeing where it's splintered, it makes no sense. Because he's pissed off because he's got to do child support, but she's sitting on the house and his credit's tied up, and
Right.
It's a nightmare.
Well, as a recent graduate, a lot of this to me seems like common sense, and I mean, I say that as a compliment.
I'm not a recent graduate, and to me it seems like common sense too.
One thing that struck me is the pro bono requirement, or lack of requirement. And I
Yeah.
thought coming to law school that was just required, that you would have to do these hours. Why? I mean, that seems like a quick fix.
It is a quick fix, but I haven't thought it through. There are some people out there who I respect who do a lot of work, for instance, with these low bono and pro bono and modest means programs, they're actually opposed to a requirement as opposed to an aspirational goal. And the reason is they think if there's a requirement, people will stop going to their program. Once they get to whatever's required of them, that's it. They won't do any more. And I think we have to be cognizant of the fact that if they're concerned about it, people who are doing this every day, then maybe we should think twice before we all of a sudden say, hey, a lawyer, you have to do X number of pro bono hours. I do have some, I have a lot of thoughts. I know over in New York now, is it only if you take the bar exam early in your 3rd year that what you have to do in exchange for that is to give 50 hours of pro bono work? Or is it everybody who takes the bar exam?
Has to have it as a 50-hour pro bono requirement.
I don't know why we're putting the
But you
requirement on
can
the
get paid,
people
they
who
can
are.
define pro bono.
Right, but it makes no sense to me that if we're gonna have a requirement, we're gonna put it on the people least likely to be in a position where they can be giving away their work.
At least
Because they're the only
experience.
ones that
Right.
they can make do it.
Right, exactly. They know the organized bar would never go for that.
But one of the problems, so I just flagged for the students who I haven't had yet, if I have you already. As a legal services lawyer, that was my first practice. I have a real passion for what you're talking about, and I agree. You don't want to let the perfect be the enemy of the good. And Washington State is having an experience right now of separately licensing paralegals. So we're going to get to see what happens. But I remember providing draft counseling advice during the Vietnam War as a law student. And I didn't know that I needed to be supervised. And we had a street clinic and we set it up. And the advice we gave was terrible. But I only know that in hindsight.
Right.
And that has scared me all through my life, seeing all the bad advice people get. And you had one example where you said, who is hurt by the ghostwriting? The person who's hurt by the ghostwriting that's incompetent is the client, because they have paid for something and they don't know what they're getting.
I agree. And I didn't say it, well, I agree, but I want to make sure that we allow ghostwriting, but if you ghostwrite and you give competent advice, you are still subject to a license. I mean, excuse me, if you give incompetent advice. I don't mean that they should be in a secret world. I think it should be allowed, but you're on the hook if you do it wrong.
Sheila.
One thing I think that could help is if there was a lot more of the family court has moved towards these fill-in-the-blank forms, and what they did is they asked the attorneys to stop using your own complaint. They want you to use the family court form. They don't have the same for civil stuff. Like if you want to file an eviction complaint, there's no boilerplate eviction form, complaint. So I think some of that stuff would help, because a lot of times what I find, I have the second largest kind of emerging law, I think, is landlord-tenant stuff. And what happens is people go way, way, way too far down the road before they go to seek help. So, I get cases with $4,000 and $5,000 in arrearages of rent. It would be easier if the person could have gone right in, the manual is there, but it doesn't tell you how to actually go forward and file your complaint. So there's great information in this Vermont Housing Coalition's, helping landlords understand the law, but there's nothing to help them actually file.
So, larger point forms. Within the judiciary right now, there's a heated debate going on as to the value of forms. I can't remember who's on which side, but the court's Civil Rules Committee and the court's Pro Bono Committee are at loggerheads over whether forms are a good idea or a bad idea. Whichever one is for them wants more forms than just in family law. They want it expanded, like you're saying, throughout the civil system. There are people who think our forms don't help people at all. They, in fact, make it worse for them because the forms aren't clear. You need really a lawyer just to get through it. And some people go so far as to say the forms are intellectually dishonest in that they lead someone into thinking that they can do this without having a lawyer or legal advice. Other people think forms are great because they free up just for the very simple reason that they free up the staff at a courthouse to do their work instead of constantly having to answer questions from these pro se litigants. I don't know really where I fall on that. I'm going to let those two committees, I think it's probably a little bit in between. We can have forms, but let's make sure they're good forms.
I know people have to go to class, so why don't we give people permission to leave, but nobody is, no one's coming into the classroom now, so if you've got a question for Michael,
On any issue you have, yeah.
Another one on this ghostwriting. Why, what am I missing? Like, why don't they just write their name to it and say prepared by?
Legal aid did that for years. They were using
Yeah,
it,
I
and
know.
that caused a controversy.
That's it. I thought about that last night, looking at the case from New York where the lawyer got in trouble. Why didn't the lawyer just put his or her name on?
Because, one thing I've seen is because they advise both sides. And they've got a conflict, and they're collecting money from both sides. I know, but they're doing it.
I haven't seen it.
Yeah.
But I think the reason I I go to these lectures and the one on unbundled and bundled
Yeah.
representation, I think that's exactly what people would come to you for. Is
Right.
What does this mean? What's the difference between legal rights and responsibilities and physical rights and
Right,
responsibilities?
and, yeah, we already sorted out who's getting on the property. We just want to know what this means with the kids, yeah.
Yeah,
And,
but I think that the reason that I think judges know which ones are done at help, but I think it does prove to be a disadvantage. The courts do and will go out of their way to protect a pro se litigant against an attorney.
Yeah, I've heard that.
Protect.
I agree, but I'm saying that in other words, if you come to somebody and each side goes and gets an attorney to help them draft their paperwork, it doesn't help them make those arguments when they go to court. But I don't understand why it would be an advantage or disadvantage for them to disclose that.
Right.
I think that everybody knows you have the right to go out and
avoid
do
the
that.
conflicts that
Right.
they couldn't follow. Can I ask a paralegal question?
Sure.
Which is, I don't understand what's the beauty of having licensed paralegals operating independently? Why lawyers just don't supervise paralegals and charge less?
I think,
You see that in Puerto Rico a lot.
I think that using I think you can make a business model where you just get a bunch of if we would allow it, get a bunch of paralegals and do all the work that you're charging less money for.
But we see that, right? I mean.
I worked at a law firm that was like that.
Say again?
I worked at a law firm that was like that. It was a foreclosure and real estate law firm. We had, 300-400 paralegals and 30 attorneys.
Yeah, and I think in Vermont, if we let paralegals go into court in certain types of cases, it would be a great business model.
Uh-huh.
But we have to let paralegals do stuff. We have to let them argue in court. And I think the key, we referenced in our report, we have to let them, if they're in court on the spot, have some sort of settlement authority. But there's a lot of people who are opposed to that, yeah.
Another one, sorry.
Go ahead.
I heard, I think VPR maybe last week about there's 2 companies now that have started going and setting up firms in Walmart. And
Yeah.
Have you seen any of that, any interest in Vermont or any?
I think there will be. I think Walmart is such a huge business that, first of all, Walmart doesn't own the firms. The firms themselves are just essentially renting space from Walmart, like the Dunkin' Donuts at the front of Walmart does.
Right.
So I don't know that that'll happen in Vermont. It's not too far off, though. I don't know when that will happen in Vermont. I don't think it's too far off because it's now happening elsewhere. I think what will happen elsewhere sooner rather than later is Walmart will decide, well, wait a minute, rather than just charge these people rent, we're going to hire Walmart lawyers and we're going to put them in every store. But they can't do that right now, really, the lawyers right now can't do that under the rules of professional conduct.
Because of the ownership?
Yeah.
Well, and that's the other one, you say, do people,
Right.
I'd like to suggest that if we allow non-lawyers to own some or all of our practices, we're going to be recreating the medical nightmare that we're seeing right now, where doctors, my husband's on Dartmouth Medical School faculty, doctors can't practice medicine because accountants and bean counters are telling them,
Right.
you can't do this. And I think it would be a disaster for the legal profession to do the same thing,
Yeah.
to give up that.
That's one of the arguments against. That happens right now in insurance defense law, where I have friends who work in insurance defense work who is constantly being told by some adjuster, no, you can't go take that deposition, we're not paying for it. And that's nuts. His judgment is affected by a non-lawyer.
Well, as you know, maybe I'll have
That's
it
a
on the
client, Mike,
insurance
that's
class.
not an owner. There's a big difference.
True, but I
You may
also.
have a contract, but if that guy, if your client contact is leading your client astray, you go over his head or you get rid of the client. You know that a lot of the big firms, you can't do that, but that's a big difference between the owner who's writing your paycheck versus just the client.
But I also think maybe there's ways that are less than full on. No, I don't see right now, why can't a family law practitioner be in partnership with a family counselor? And they both own the business together.
Yeah, well, the same way doctors wind up buying the laboratories. Suddenly you're going to do a lot of tests.
Or, why can't you have an outside investor invest in your firm, and you use the investment to make capital improvements specifically with technology that allow you to become more efficient with your clients?
Didn't we call those banks at one point?
Well, that's the big fear, that the banks will own all the law firms, but I think there's ways to do it that we don't get to that point. I think it's at least a discussion worth having. These are great points. I've tried to raise the discussion on my blog and nobody got involved.
I think the discussion is a very important one.
Yeah.
And the whole profession has to have this discussion on a regular basis,
Right.
because otherwise the changes are gonna come anyway.
That's exactly my point, that maybe it's a good idea or maybe it's not a good idea, but we have to decide that, because I think, and I heard somebody say it in Montreal at a conference I was at, if we don't decide that as a profession, somebody else is going to decide it for us and it's going to be too late.
Perfect.
Yeah.
Thank you again.